All we have on our agenda item today is possible final action on some bills previously heard. And I think we're going to start looking at Senate Bill 323 and ask for an overview and reminder of what that bill is about from Nick Myers, our reviser. Oh, whichever's convenient. If it's easier to do it back there, it'll be fine, Nick.
So committee, Senate Bill 323, and I don't know if you're pulling that out of your folders, this would require that prior to the construction of any wind or solar generation facility, that a lease or easement document, that instrument must meet the requirements of this bill. So the first thing is that the instrument must contain a cover page that has a statement to property owners, providing some information to property owners. And you can see that in the bill and also in my memo on the bill. Additionally, each lease or easement must be held for 10 business days, so a little waiting period there following the delivery of the first proposal to execute that lease or easement. Additionally, that document must be free of any non-disclosure agreement that applies to those terms or conditions in that proposed lease or easement. The bill would also require the developer of the facility, of a wind or solar facility, to enter into a facility agreement with the landowner prior to an execution of a lease or easement. This facility agreement would have to preserve the right of the landowner to continue to conduct business operations, prohibit all parties from the agreement from collecting any hunting fees on that property. It would require the developer, owner, and operator to comply with federal and state law and not make the landowner liable for such legal violations. It would allow it must allow the landowner to terminate the facility agreement if the facility has not operated for 3 years, unless the landowner continues to receive the normal lease payments during that period. It must clearly provide in writing the circumstances that would allow payments to be withheld from the landowner, and it must require the developer, owner, or operator of the facility to carry general liability insurance for claims arising from any injury or damage relating to the construction or operation of the facility. Senate Bill 323 would also authorize a court to alter or void any lease or easement that does not comply with the requirements of the bill or order any other equitable relief. And Mr. Chairman, I'd be happy to answer any questions or proceed as you wish.
Thank you, Nick. Committee, any questions about this? Senator Francisco? Oh, Senator Peterson, sorry about that. Okay.
Not necessarily questions, but I do have an amendment if you're ready.
Mr. Chair, could we have questions from the reviser and then start working the bill and have amendments?
Yeah, maybe just clear up any questions real fast, and then we'll go to the amendments, Senator Peterson, if that's okay with you. Okie doke. Let's, Senator Francisco, any questions?
Thank you, Mr. Chair. I just wanted to be sure I understood that in Section 1, if leases had already been signed, but the construction of a facility hadn't started, this bill would retroactively nullify those contracts?
Mr. Advisor, any answer on that?
So this bill, as it's currently written, would apply prior to the construction of any facility. So any written instrument that conveys a lease or easement would have to comply with the requirements of the bill if the facility has not yet been constructed.
Thank you.
Would that be under construction or completion? I mean, when we're saying under construction, it would apply to current construction, correct, sir?
Yeah, the bill doesn't speak to whether you're just broke ground or the timeline of construction. It just simply says prior to the construction. So there might be if ground is broken on the construction and it's just began, those facilities might be exempt and, or the lease or easement documents would probably be exempt from meeting these requirements.
So it's mostly prospective, correct?
I would say it's prospective in the fact that it applies prior to the construction of any facility. So it's prospective in that regard, but certainly there could certainly be an argument that some lease or easement documents that have already been executed, that the construction of a facility has not been started, could be captured within this bill.
Senator Olson?
Yeah, and that's just my point. You know, the lease could already been entered into, but a court, it looks like to me, could deem, you know, these leases not valid, you know, if it didn't meet these terms of this agreement. So I don't know. I don't know how anybody can support that, but I mean, I think it's property owners' right to do with what they want to do. And so I don't know. I can't support this bill.
Is there, Mr. Advisor, is there any statute or any issue that you would see that you're aware of that would create issues for us?
Oh, Mr. Chairman, I don't know exactly how to answer that without kind of maybe pointing me to a specific specific part of the bill or something that you're looking at.
The, let me look, give me a second here just to make sure.
Mr. Chairman, when you get a second, I got to follow up.
Sure. Very good. Yeah, go ahead, Senator.
Yeah,
Olson.
I just want to make sure this, I believe, one of these bills, one of these two bills, we heard testimony that this would interrupt existing leases and could allow, be an opportunity to go to court. And, you know, I struggle with that. And, you know, in here, you're advising people to get a lawyer. I don't know, to me.
That's a suggestion, but we do have an amendment, I think, that the revisor just pointed out that will probably answer some of these questions with regard to the prospective nature of that. But I think what we'll do, Senator Peterson had a request for an amendment, so if we can go forward and hear Senator Peterson's amendment first, and then we can work the second amendment that I think will answer some of the problems with the instrument that conveys estate or interest. So Senator Peterson?
Thank you, Mr. Chair. I have an amendment that basically strikes Section 1(4)B. It's a section that prohibits the landowner from entering into any hunting leases while they're waiting for the construction. I think we need to be encouraging more places for people to be able to hunt, not less, and that's pretty much all it does.
Thank you, Senator Peterson. Any discussion, committee, on that portion? Yeah. Yeah. Senator Olson.
Yeah, I mean, I support the amendment to allow the landowner to be able to lease his ground for hunting because we don't want to restrict that. But I mean, when you stop and think about the underlying bill, I mean, that, to me, that just tells you that you were going to restrict someone's right to be able to lease his ground for hunting, so.
Any other discussion?
Need to put that in a motion so you get a second.
Yeah, yes. Let's put this to a motion.
Mr. Chair, I move that we adopt the amendment.
That has been moved by Senator Peterson. We adopt the amendment regarding the hunting. Do I see a second? Second by Senator Corson. All those in favor say aye. Aye. All opposed, no. The amendment passes. We are back on the bill. I have an amendment that does help with the, I think, the issue at hand, and we'll pass that out. And I'll let the reviser explain this amendment. We've got actually two parts to it. There's a balloon on the back, but we can speak to the first part of the amendment on section 1.
So, Mr. Chairman, thank you. This amendment, committee, as you see on page 1, would state that it's prior to the construction of a facility, any written instrument that is executed between private parties on or after July 1, 2022. So it would specifically apply to leases and easements that are entered into on and after the effective date of this bill. And then on the back page, page number 2, you'll see an amendment to exempt those electric generation facilities that are designed and primarily used to offset part or all of the energy requirements of the premises upon which the facility is located. So those personal solar generation and other personal generators would be exempted from the bill.
Committee, any questions? Seeing none. Yeah, Senator Bowers.
Thank you, Mr. Chairman. In B on the back, does that mean solar panels, like a solar panel farm? Not just a small generation, is that what that's directed at, like panels?
It would be like a personal, solar panels on a home, solar panels in, just out on a farm by itself for augment generation, but not an industrial. So that's the intent of this amendment, to try to clarify on that. So it does not include any electrical generation facility that's designed and used primarily to offset part or all of electrical energy requirements of the premises. I know there are some private businesses that also use that, but they're not doing it on an industrial scale, more for their own plant work or things like that.
So if I can ask you, if a company wanted to have a line of solar panels that was separate from the generation, just for solar generation, so that would not be allowed, but a personal one would be? Do I have?
No, I think in this case, the way I read it and the way it was designed was, say you had a company that wanted to augment their electrical generation with solar, that this would allow that to happen and fall outside of that bill. I think this is kind of aimed at the large industrial solar that is designed specifically for electrical generation for the grid and to supply it, to Evergy or another company that provides electrical, solely for electrical purposes. So these are more of that type of situation.
Okay, thank you, Mr. Chair.
Sure. Senator Olson?
Thank you, Mr. Chair. So I'm guessing the one down in Johnson County, this would catch them, and they would not be allowed to build that facility that they're trying to build down there now. How about the colleges? There's colleges that have built small solar or wind projects across the state. There's several businesses. I mean, I see that kind of in a gray area where it might capture some and not capture others, and they might be hurt with that amendment. But here again, I mean, we're just getting into contract law on this and trying to rewrite contract law. And I don't know, I just don't support the underlining bill.
And you've made your point on that. This would not prevent industrial solar from being constructed, like the one in Johnson County, for example. It would not prevent it. It would just, they would just have to fall under the this bill, and it wouldn't prevent some companies, like we've discussed, from putting in their own private solar panels to be able to, if they so desire, to use it on their property. This is more for the landowners who might be thinking about signing a lease, that it gives them just some advice about retaining an attorney, gives them a little bit of time to consider that lease, because some of these land leases are for many, many, many years. So it just gives them a little bit of a grace period to consider the situation, but it does not prevent the construction of an industrial solar facility.
Is facility agreement defined anywhere? I don't see it is.
Perhaps not in this bill. Mr. Advisor, is there any concerns with that?
Senator Olson, there's not a specific definition for facility agreement, though the exact requirements of what must be included in that agreement are there in the bill in paragraph 4. Although not an exact definition, the requirements are in there for that agreement.
Committee, any other discussion? Seeing none, I will move my amendment. Do I see a second? Second by Senator Peterson. All those in favor say aye.
Aye.
All those opposed, no. The ayes have it. We are back on the bill. Division has been called. All those who are in favor, raise their right hand. All those opposed, right hand. The amendment failed. We are back on the bill. Any other amendments, committee? Seeing none, we will, do I have a motion to move the bill? Seeing none, we'll leave that open and move on to Senate Bill 324. I have Mr. Advisor pass that out, or, well, I actually give him a bill brief.
Committee, as you're opening your folders and pulling out 324, I'll run through it real fast. This would amend current statute, KSA 582272, which relates to wind and solar leases and easements. And what this bill would do is it would state that a wind or solar lease or easement would be void if within 5 years after the execution of that lease or easement, the property does not have a certificate of site compatibility or a conditional use permit issued for that facility, if that's required, and the property or this facility does not have a transmission interconnection request that is either in process and not under suspension. In addition, a lease or easement would be presumed to be abandoned after a 36-month period or a 3-year period with no construction or operation of the facility unless the developer, owner, or operator of the facility files a plan with the Board of County Commissioners outlining the steps and the schedule for the continued construction or operation of the facility within that period of time. If that entity does not file such a plan, the landowner under the bill would be authorized to mail a written intent to terminate the lease or easement to the entity. And if the entity or the owner or operator or the developer fails to provide a written objection to that intent to terminate, within 60 days following the receipt of that notification, the landowner can file a notice of termination with the Register of Deeds in the county where the property is located to terminate that lease or easement. And Mr. Chairman, I'd be happy to answer any questions if there are any.
Thank you, Nick. Committee, any questions on this one? Senator Francisco.
Thank you, Mr. Chair. I'm wondering if the revisor can help me understand the relationship between the provisions. This would be starting on page 1, line 33, that it's going to be void within 5 years after the lease or easement commences, and then presumed to be abandoned after 3 years. Can you help me understand the relationship between those two time periods and how that works?
Mr. Advisor?
Yeah, so the voidance would apply within 5 years for those two things happening. The facility operator would need a certificate of site compatibility or a conditional use permit, and then also that transmission interconnection request. But that paragraph 2 there also says that it would be presumed to be abandoned if there's a period of 36 months that have passed without construction or operation of the facility. So there may be some overlap there between those two provisions, between the abandonment and the avoidance provisions.
Senator, go ahead,
Thank you.
Senator Francisco.
Mr. Chair, if I may, one more question. So then I'm looking back at the void within 5 years after the lease or easement commences. If you have to have a certificate of site compatibility or conditional use permit, I'm assuming you could only get a conditional use permit in those counties that are zoned. And then I'm not aware of any instrument that's a certificate of site compatibility, and would be concerned that how would a county adopt that except through some kind of zoning or planning mechanism?
Mr. Advisor?
Oh, I don't know that I would be able to answer that without some conjecture in there. I'll stick with the language in the bill right now.
I do know there are conditional use permits issued by counties. The site compatibility may actually come from the wind company itself or the solar company itself, I believe, showing that it's compatible, or they run it through the county. That's how I understand it.
I mean, certainly under the bill, counties would have to establish a process because both are required, a certificate of site compatibility or a conditional use permit, and then also that transmission interconnection request. So there would have to be some type of process to issue a certificate of site compatibility or that conditional use permit in order to proceed with development.
So the county could develop either or the conditional use permit without having to be zoned, correct?
I'm not exactly certain on that, and might be best to talk to county folks on that one.
I believe that's happened, and maybe I'm incorrect on that. But again, the intent of this bill is, you can sign a lease, but if nothing is happening, and again, goes back to the fact some of these leases are very long, and nothing is happening, and there's no intent to get anything done, then it gives the landowner an option. And I believe it's an option. They don't have to execute the voiding of the lease. Later on in the bill, it shows that they can ask for it. They don't have to ask for it to be voided. This does not automatically void the lease. It says if that entity holds such lease or easement for the construction or operation, does not file a plan blah, 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 blah. On line 11, page 2, the landowner may provide by certified mail or other personal delivery to the holder of such lease or easement a 60-day written notice of the intent to terminate the lease or easement if, within the 60 days of the receipt of such notice, the holder of such lease or easement fails to provide a written objection to the notice by certified mail or other personal delivery, the landowner may file a notice of termination. So in other words, it gives them an out if nothing has been happening for a period of time. All the wind company or the solar company would have to do would be to answer that 60-day written notice and communicate with the landowner, and this wouldn't kick into effect.
So, Mr. Chairman, you're correct under that abandonment provision that is a landowner choice whether or not to file that termination of intent.
Senator Olson.
Couple things. First, I think it would make the counties have to be zoned. There's a lot of counties out there that don't want to be zoned. So I think, for several reasons, they don't want, people telling them where they can park their truck or how they can raise their livestock or all them little things that, when you buy a farm or out in the county that, you don't want people doing. And then I think the second part, here again, we're interrupting these long-term leases. I think we're driving ourselves right to the Supreme Court if this bill passes. And, when them leases are interrupted, there's going to be a list of people filing court cases against the state. These contracts on these wind farms are 20-year contracts. And they have all these farm owners that have the leases. There's a lot of people, and I think, by moving forward,
There are some leases that are 90 years.
there some are, and
Yes.
I'm in the real estate business, and most of the buildings downtown Kansas City, Missouri, are on at least 99-year leases. I'm familiar with the lease that was entered in with the original, I think it was Maristar Argosy Casino. It was like a 99-year lease. There's a lot of that. You have oil and gas people all the time enter into leases. And, some of them leases in western Kansas have been alive for 100 years. And on some of them oil and gas leases. So, there's multiple kinds of leases, but I see this bill as an opportunity to disrupt them lease, harm them people, and, there'll be victims on both sides of this by the people that had the contract and now they're not selling the power, or they're, there's a whole host of harm here. And I think there's a reason why the government hasn't interrupted contract law in a long time. That's just my opinion, because it's working fine. It's what the courts are here if there's a problem. The county commissioners, the government local knows if their county wants to be zoned or not. And, here is a good example. The state's trying to force the county to do something that they don't want to do. They're elected by the people, the county commissioners. They don't have to zone them counties, and we're trying to force them. So
This does not force zoning. They can adopt rules without forcing zoning on this. They can adopt a conditional use permit process in the county that would not require them to adopt zoning.
I know a lot of smart county commissioners. They've looked at this, and
They've looked at this specific bill.
No, they've looked at the wind legislation. Some of them county commissioners don't want to be zoned, and so, but that's just my opinion.
Understand
So
that.
I'm not going to support the underlining bill, so thank you.
Committee, any additional discussion? Senator Francisco.
Thank you, Mr. Chair. So when we were talking about the 5 years and the 3 years, my reading of the bill, and this is page 1, lines 34 and 35, it says, shall be void. So the 5 years is a shall be, and then the 3 years does allow for that interaction. But it also says presumed to be abandoned if a period of 36 months has passed. And then to deal with that, you have to file a plan with the Board of County Commissioners. But I don't know how you file a plan with the Board of County Commissioners. You know, later on, it talks about filing things with the Register of Deeds. That's often done, but I don't know how the county commissioner would have a way to file things, or how they would keep track of those files if they don't have a planning and zoning office. But
Any other discussion? Senator Peterson.
I don't know if it's the right time, but I do have an amendment on the presumption. We heard testimony that it takes 5 to 7 years to build these. I think the presumption of 36 months is way too short. Just to get a 325-foot crane could take 18 to 24 months to get it delivered and on-site, and then you're probably paying $250,000 to have that delivered. So I have an amendment, if you'll pass it out, that changes those two in that section to 7 years. I wish I would have requested for the first 5 to be 7, but I did not do that. So we'll go with this amendment first.
Okay. Would you offer a conceptual amendment to change the first 5 to 7 as well?
If you would allow that, I would do that.
I certainly would. Would that be within order, Nick, to,
Mr. Chairman, does your rules allow conceptual amendments?
we do have the latitude, I believe, to do so. I'll have to look.
Okay.
Yeah, Mr. Advisor?
I always defer to the chair to run his or her committee, Mr. Chairman.
Thank you, sir. Would you propose, Senator Peterson, to change the void if within 5 years to 7 years?
If that's allowed in the committee, I would. I do know the one that I have drafted only takes care of the presumption to be abandoned. But I would like to do the other one, but I did not have that drafted.
It looks like a fairly simple amendment. It's just changing 5 to 7 on line 35 of page 1.
If it's allowed, I'd include that in my amendment.
I believe we can allow that.
That's a motion.
That's a simple way to do it. We've got a motion by Senator Peterson. Do we have a second? I don't see one, Senator Peterson. I'm sorry about that. So we're back on the bill. Committee, any further discussion on the bill?
Mr. Chairman, I don't know if you're allowed to table bills or not. I don't think you do in your rules, but if you do, I'd make a motion to table.
Let me, in the rules, I do have the option to table or not. At this time, I won't allow that motion. I would like to talk to the revisor. It's apparent we have some concerns on this bill, and I think what we'll do is try to continue the discussion. I have no other business for the committee at this point. Committee, thank you for your work. We appreciate it very much, and with that, we're adjourned.